It seems as though in today's world we cannot sign up, buy, use a service, or connect with friends without having to sign off on a terms of service agreement online. In a survey by The Guardian UK, it was found that only 7% of online users regularly read the terms of service when signing up for things online. But what do these terms actually mean for our rights of privacy and ownership? And sometimes more seriously, what legal position are we put in if we violate these terms of service? Today I will look at the terms of service for the popular content sharing site Pinterest, a social networking site which allows users to pin content, both original and from around the web, to a board which can be viewed publicly. This content usually then links to a third-party website where the original content was found. In March of 2012, Pinterest updated their terms of service, privacy policy, and acceptable use policy after much debate and criticism regarding the site's dubious copyright policies. When signing up for the site, you agree to abide by these rules and regulations as a user of the platform. So what are your rights and responsibilities when using Pinterest? The Terms of Service policy states 12 sections of terms users agree to comply with when using the platform. Of these 12, the most important aspects affecting users of the site include Term 1, using Pinterest. Anyone over the age of 13 can use Pinterest, including businesses. To do this, you agree to a limited, non-exclusive, non-transferable and revocable license, which basically means your account and its details can be shared by Pinterest, that the account should be kept by only you and not transferred, and that the account is able to be revoked by the site. Term 2, content. By using Pinterest, you agree to retain all rights and be solely responsible for the user content you post. Your content belongs to you, but Pinterest can show it to others and others can repin it. Also be aware that the site maintains the right to continue using your content even after you've deleted your account. Term 3, copyright. Pinterest has a copyright policy which complies with the USA's Digital Millennium Copyright Act of 1998. They state that they agree to respect the intellectual property rights of others and that they expect their users to do the same. When users do not, they reserve the right to disable or terminate infringing users' accounts. Term 5. Third-party links, sites and services. Pinterest is not responsible for links to third-party sites or anything that may be harmful on those sites. Term 7, indemnity. If you use the site for commercial reasons and Pinterest is subsequently sued for any damage your business does on the site, your business will have to pay all of the costs incurred. Term 8, disclaimer. Pinterest takes no responsibility or liability for any bad user-generated content. Term 9, limitation of liability. Again, Pinterest states they won't be liable for pretty much any of the bad things that could ever come from a user-generated site. In other words, don't even try to sue. One of the main concerns of Pinterest has been on their infringement on copyright practices by users pinning works that have not been lawfully released or licensed for reproduction. With the reworking of the Terms of Service policy, including their copyright policy in 2012, you should be aware that it is likely to be you, the user, who is liable for any copyright issues rather than Pinterest. Pinterest ensures they aren't liable by harbouring under the Digital Millennium Copyright Act, because firstly, they have told users not to use copyrighted works, and secondly, they have a system for taking down the infringing works. So now to place the blame on you. Remember in the sections of the Terms of Service that it states you are solely responsible for content you post, and also that you have already agreed not to infringe on intellectual property rights. In simple terms, if the suing gets underway, you are not likely to be protected under any legal frameworks. However, Pinterest can protect itself with its compliance in the Digital Millennium Copyright Act. So, how do you make sure you don't get yourself into hot water? Basically, follow these 4 rules. Firstly, only post things that are in the public domain. Secondly, you can post things that are covered by a Creative Commons license, however, make sure you stay within the terms of the license. Thirdly, post anything that you have been given permission by the original author to copy. Lastly, If in doubt, it's always best to ask the original content producer for their permission, and you can't go wrong.